Good morning. Thank you for coming today for CMC hearing. As usual, the claimant will start for proceeding and will fix timetable for the case, unless if you have any application to deal before the CMC start. Yes, Mr. Musab.
Yes. Your Honor, as stated in the case memorandum, that the claimant in brief was employed by the defendant as a managing director from September 2011 under an employment contract. The defendant is a company incorporated and registered within the DIFC. It is an employment issue actually, from our side at least. In our particulars of claim filed on 11 June 2014, we have asked for the remuneration and plenty of employment benefits from the defendant as per the employment contract, which we can deem as a specific performance for their duties under that contract. The defendant, in reply, filed a defense and counterclaim on 8 July, which has been amended and filed on October 6, 2014, based on the order delivered by Mr. Justice Roger Giles. That order permitted them to present one of their claims regarding the transfer of shares for the favor of non-litigant party. The claimant, the defendant, also, as he filed a counterclaim, and he counterclaims for relief, injunctive relief, and losses incurred arising out of alleged poor performance and failure to comply with the defendant's instructions. And he alleged that the claimant was only terminated for cause without notice on 30 June 2014 in a meeting, 2013, sorry, in a meeting held between the claimant himself and the defendant's chairman, Mr. Chokri. We replied that alleged oral termination never happened, and the claimant actually continued his employment up to February 2014 based on 3 months notices. However, we state that resignation submitted in November for 3 months notice has not been activated from the defendant, as the claimant's name was still listed as a managing director after that period, and the use of course his residence still valid after that period, and despite of several claims for deleting his name as a managing director and also cancellation of his visa. A material procedural history has been identified in the case memorandum. It is covered by the description as we made right now. The list of issues that the claimant deems relevant to this case. First key question which we deem should be answered, and its answer will for sure affect the whole case. The first one is, was the claimant actually terminated formally for cause without notice at a meeting between the defendant's chairman and himself on 30 June 2013? And also several other questions and issues, like, was the claimant dismissed for cause and in accordance with his contract? Is the claimant entitled to any employment benefit? Okay. This is in document 12 of the bundle.
Yeah, I'm aware.
Also, we deem that some issues relate, some other key issues and key questions relates to the alleged misconduct and failure for poor performance and misappropriation of certain amount of more than $700 and whether the claimant failed or not to comply with the reasonable management instructions. Also, did the claimant breach any post-termination restrictions under his contract of employment? This refers, of course, for the non-competition clause in the employment contract. Some other issues of fact are listed in our case management, case memorandum. Issues of law, as we believe, as the claimant believe, that does the alleged termination for cause established and it happened, which is denied from our side, does that alleged termination for cause entitle the employer, which is the defendant, to deny the employee's claim for salaries, whether fixed or variable, annual leave, and other employment benefits? Is the alleged oral termination for cause in conformity with RDC 17.14? And does the IFC employment law recognize unfair dismissal compensation? Agreed fact.
As a question to the court?
As a question of law, as an issue of law in our case, because we claimed for unfair dismissal compensation.
Does the IFC employment law recognize the unfair dismissal or not?
Yes.
Okay. I will refer you to the two cases, leading cases, Lutfi and Difki, and Hana al-Harz and Difki. This is most of cases dealing with this type of...
Your Honor, I have already reviewed the two cases, and I reviewed 2-3 judgments issued by within the DIFC courts for this issue, that the DIFC employment law does not recognize unfair dismissal compensation. However, we have an argument that we believe that it should be addressed and reflected to Your Honor to be decided after our argument on this issue. Agreed facts as listed in our case memorandum, that both parties agree that the claimant didn't receive any of his employment benefits after 30 June 2013, because actually the defendant alleged that the claimant was terminated on that date. So, of course, they admit that no benefits have been paid to the claimant after that date. As Your Honor note that we didn't agree on the case memorandum, some of the issues, most of their amendments, the defendant's amendments with the case memorandum have been agreed from our side. However, we deemed that some other issues of fact are key issues to this case, and we prefer to keep it, but he insisted to not approve to do that issues. In the claimant's management information sheet.
Okay, before we move to that point, now, list of issue, my understanding that there is disagreement on list of issue, right?
I think we're broadly in agreement on most of the issues. The only issues we don't have are in relation to whether there is unfair dismissal compensation with the IFC. We say that that's not an issue. That's been resolved emphatically by the two cases that Your Excellency has already mentioned. And in terms of the other matters on the list of issues, in terms of the issues of fact,
On tab 12?
yeah, you'll see that the defendant's list of issues are at tab 11.
Okay.
And can I invite you to ignore the first document you see there, which unfortunately...
The image?
Well, the email and the attachment, which says case memorandum, unfortunately, this was printed out by the claimant, which was never the intention of the defendant. If you turn a few pages forward, you'll see the tracked change version that was supplied by the defendant to the claimant.
This is the amendment one?
Yes.
Okay.
Your Excellency will see that, ignoring the case memorandum for a moment and moving on to the issues under the list of issues,
Okay.
you'll see the issues have in fact have been redrafted in a way that doesn't change them substantively, but in our view makes them more finessed. And you'll see that over the page, when you get to E and F, we we have deleted what are no longer issues in the case because of the amendment to the defendant's pleading and the removal of any claim by the defendant to the transfer of 25.5% of the shares in Frontera. So that's no longer an issue. And what we've done, for the sake of brevity, is we've combined issues of law and fact in a case of this kind, which is relatively straightforward. So we've deleted issues of law because they are, if you like, intertwined with the issues of fact. But the substantive issues remain the same. We just say that they are more precisely set out as a list of issues.
Which is the most important issue, the 30th of June,
Correct.
2013. Does the claimant sacked or terminated by the employer or not?
Precisely.
Yeah, and if you establish that the claimant has terminated by the employer, then he will not be entitled as a Article 59A.
Precisely.
For cause, I mean.
For cause, of course. We have to establish that it was dismissed.
You have to establish that.
So it wasn't terminated on that day.
Okay, then in conclusion, there is no issue in list of issue so far. And I can say that the concept of the unfair dismissal will keep it to the judge, who's myself or the other judge who are going to decide the case, to write on that.
Your Excellency, you also see in the list of issues, and this isn't disputed, that there is a counterclaim, a substantial counterclaim, by the defendant. So after we pass A, B, and C, we get to D. Did the claimant misappropriate the sum of USD 77778? Did the claimant fail to comply with reasonable management instructions? Misuse of intellectual property? Related party transactions?
This is a counterclaim.
Yes, but we combine them with this issue. And I don't think there's any dispute that those are.
We agreed to that, actually.
Okay.
Just for the sake of completeness.
Then, yes, Mr.
Yes, I have a point here for his list of issues, as he deleted question E, which provides that is a PDEL entitled to acquire 25.5 of the share capital in Frontier.
This is deleted.
Yes,
There is
actually,
no dispute.
no, there is an issue here, actually, Your Honor, that it is deleted as a claim, as a relief. But he insists that we failed to obey the instructions of the defendant to transfer that shares to PDEL, which is, as alleged, an associated company with the defendant, and accordingly, this is a breach to the claimant's fiduciary obligations, and accordingly, he's entitled to dismiss him for cause. So, actually, yes, it was deleted from the relief, but we asked Mr. Justice Roger Giles to delete the statements in the substance of his counterclaim, but he rejected that, and he stated that should stay because it is a reason for
cause.
Yes.
For cause. This is a reason for cause. As I saw Justice Roger order.
And that's why it's included in E. Did the claimant fail to comply with the reasonable management instruction? That is the management instruction that's been pleaded.
No, I prefer to be more accurate and specific to the issue because this is the main reason.
Okay. For me, there is no. I can say it's fine, and let's go to the timetable, CMC timetable, straight away.
Your Excellency, do you have a copy of the case management, draft case management order?
Yeah. Which is this morning I received it.
My apologies.
Now, in which case, in which draft you're going to work, defendant or a claimant?
Well, can I just make this point? I know that Mr. Mossar, on behalf of the claimant, will invite you in a few moments to consider the appointment of an expert.
Nothing here before me.
Pardon?
Nothing before me. You're asking for appointing expert.
Precisely. You'll note that the claimant's timetable is affected by direction, a proposed direction for the appointment of an expert, which of course delays matters. That's the principal difference between our draft case management order.
See, we'll come to this point when we're dealing point by point.
Certainly.
When we reach to the expert point, we'll see how it's necessary to appoint an expert and which type of expert and for which point.
Well, in that case, can I just ask you just to distinguish between the two case management orders, because unfortunately ours doesn't say defendant's case management order, but the first date you'll see under production of documents is the 18th of December. That should identify as the defendant's draft case
Already I
management.
did. I put the orange color.
Great.
Don't worry.
Thank you.
Yeah, Mr. Muhairi.
Yes, Your Honor. For the retrial timetable, as
Give me a second.
yes,
ناصر عندك كالندر؟ خلاص. Who has a calendar here? Just to assist me.
I have one on my phone.
That's okay, fine. At least. تفضل. Go ahead. Sorry.
yes.
We confused between Arabic and English.
No, Your Honor. As stated in our draft for the case management conference order emailed yesterday evening,
And production of document.
yes, production of documents, we start for the standard production of documents to be made by each party on or before 15 December 2014.
Okay. And we'll work
Together.
together.
Yes.
It's 15 December will be fine for exchange.
Yeah, we have no problem with that.
Okay. It's number one fine. Number two.
Number two, parties to file and serve in office to produce on or before 29 December 2014.
Mm-hmm.
Your Excellency, the reason we have put the 8th of January is so it doesn't coincide with the
RDC.
with the Christmas break. Many of our staff in the DISC team are expats and are away. I mean, it's ordinarily not something that the court should concern itself with. However, I know that I'm just trying to be realistic about the timescales involved, and that's why we've suggested.
But for 15 days you cannot apply for any request? Because this is the date for the parties to file a request.
Indeed.
If there is a document you want to disclose.
Yeah, I'm happy to cooperate with the court. So I'm happy with the 29th of December. Can I make a suggestion?
Yeah.
Can I invite the court to have that deadline earlier, so that if I'm away, I will receive the request produced from the other side.
It's for me it's fine, unless if you agree on Monday.
So may I suggest then 7 days from the 15th of December,
Will
which
be
takes
fine.
us to the 22nd of December.
Doing so for us?
Yeah, both of you.
Yeah.
يعني,
What the difference? Yani,
It's
on
early.
or before, he can submit it early, but
as a deadline, what he said,
Yes.
as a deadline,
I'm
29.
talking about, you see, if we set the deadline later, then the claimant is entitled to file it later at a point where we will not be in the office. So I'm just suggesting, in the spirit of cooperation, we have it earlier on the 22nd of December.
give me suggestion. You suggest the 22nd of
22nd.
December.
yani, I believe the 22nd to be only 1 week, and actually we prepare many documents to be
Then
released.
we'll make it 8th of June, January, sorry, 8th of January.
If Your Honor agree to 7th of January,
See, end of the day, it's you both agree.
I mean, in that case, erring on the side of caution would be the
This is
right
not
thing.
my decision.
okay, it is 7th of January. No problem.
Great.
Will be 8th of January.
Yes.
But are you sure this is not a holiday?
No, I will be back in the office well
Okay.
before then.
Okay. Objection for request, if any, within 7 days?
It will be like 14, I think.
Within 7 days from the January 8th,
I agree to that.
I'm happy with that.
and will be.
It takes us to the 15th of January.
14 or 15.
Okay, check your calendar, please. I don't have a calendar.
Yeah, the 15th of January is the Thursday.
15th of January.
Yeah.
Yes, number 4.
With objections to any request introduced and made, the court will determine within the following 7 days.
Which is 7 days after 15 will be
22nd.
22nd. And are you aware how to file the reference of request as a columns?
Yes, in the red phone schedule.
Yeah. Okay, number 5.
14 days thereafter would take us to the 5th of February.
So it will be.
Okay, if there is no objection, will be the deadline again,
14 days from the original date would be the 22nd of January.
22nd of January.
No.
Where there are no objections,
If there is no objection, if there is the disclosure, it's smoothly.
We are in item 5 or item 6? Sorry.
Now I'm in item 6.
For item 5, it is
February 5th.
February 5th.
Okay. Justice by reconciliation. Did you consider that mediation or reconciliation between both parties? Did you?
we are so far apart that it doesn't seem hopeless position. There's also been a mediation previously in this matter, quite a substantial mediation, which unfortunately did not bear any fruit. So we don't see it as a useful or productive exercise at all.
As our client, I discussed this issue with our client, he is celebrating an alternative dispute resolution order to be delivered based on the rules, and he's open for any proposal as suggestion of that. Of course, it should be agreed, I think, with the other party, but this is our position already.
Okay, then there is no order just for reconciliation unless if you agreed later. We are happy to assist.
I should point out that there was a mediation that spanned a period of 4 months on various dates, which, as I say, didn't produce any results at all. So
In any circumstances, if you feel that the parties can start the mediation again, we are happy to assist by staying the procedure until you finish your mediation and regard that dispute. Okay, witness statement, number 8.
6 weeks following disclosure stage would take us to the 19th of March 2015.
And be sure 19th of March, not a holiday, because I don't
No,
have
it's a
that.
Thursday.
Thursday. And on reply, this is an exchange. Will be sign exchange the witness statement.
Yes.
Correct.
Yes.
As a point 8, and on reply will be point 9. 2 weeks to reply the witness statement.
Your Excellency, it's a matter for the court, but this is a relatively straightforward case.
End of the day, up to you.
Yeah, one of the difficulties in allowing parties to reply is then you have replies and then replies to replies, and unfortunately what is supposed to be a simple exercise turns into a convoluted exercise with each party dealing with collateral issues. So can I suggest for the time being that we leave matters as they are, so simply a mutual exchange on the 19th of March with no further directions, unless one party applies.
Mr.
Actually, I prefer, and we intend to ask for
A reply.
yes.
Okay, we'll keep it then 2 weeks after 19th of March,
2 weeks, which would be
and calendar will be
2nd of April? 2nd of April.
2nd April.
So the pre-trial review should then be...
Okay, let's come to the expert point. Yes, Mr. Musa.
Actually, Your Honor, one of the allegations made by the defendant as a reason for early termination and termination for cause that our client, the claimant, misappropriated the amount of more than 700,000 US dollar. We believe that appointment of court-appointed expert would be helpful, which he should be an accounting expert to review and express an expert opinion on the issue of misappropriation of such amount by reviewing and scrutinizing the defendant's budget and statement of accounts.
Which is disputed or not disputed?
Actually, up to now, as I know that he did,
there is no dispute point in regard that.
Yes, it is disputed that he alleged, of course, that.
But the most important point you have to establish, or both you have to establish, this is from his side, the claimant terminated on cause, and you have to establish that the employee or the claimant he resigned on 28th November 2013 with a 3-month notice, which take you to the 3rd of March.
Yes.
This is my understanding how
yes.
the case will go. Then, after you establish that, then, as you said, you want to establish there is an unfair dismissal or not. Secondly, his remuneration or employment remuneration is defined by the contract. And still, again, the expert help you in what? On which basis? I couldn't see this case as an expert case.
Yes, indeed, Your Honor. But actually, one of the allegations made that my client or the claimant, as a managing director of the defendant, has transferred with unauthorized, based on unauthorized transfer of money from the accounts of the defendant to his account, this sum of money. So we believe that if an expert has been appointed to review, because that money, as we believe and as we stated in our statement of cases, that that money has been paid based on an agreement of the defendant and based on 2 signatory persons to our client as an incentive for equity grant based on the contract. So reviewing the budgets of the defendants and their accounts, it will show that this money has been transferred to our client based on that category, which is employment benefits, and it will show, as we replied, that in Asif in 2013 they tried to change that entry in their budgets to be from incentive and employment benefit to loan and advance, and it has been objected through written letter from our client.
You have evidence, right?
We have evidence, but we prefer
You
that.
can use this evidence before the court. Why you need an expert to explain?
I think it will be conclusive because he will scrutinize and review the budgets. That is our review.
I will give you a decision on this, yes.
Just before I deal with the substantive objection, it's important to bear in mind that the appointment of a court expert isn't necessarily the last step in any court proceedings, but it's one that the court doesn't consider lightly. The court needs to give adequate scrutiny to the appointment of an expert to ensure that...
You're reading in which article?
31. I'm reading from the article 31.12.1.
31?
Yes, of the RDC.
Okay, it's 31, sorry?
31.12.1.
Okay.
Which is a restriction of expert evidence as to UA law. Sorry, 31.12. Expert evidence shall be restricted to that which is reasonably required to resolve the proceedings. And Your Excellency will be aware of the dicta of Deputy Chief Justice Chadwick in the case of Talim, PJSC and National Bonds Corporation. And that related to the appointment of an expert on UA law. And such was the court's reluctance to appoint experts that Deputy Chief Justice Chadwick laid down guidance for the circumstances in which experts are to be appointed. Ordinarily, you don't need an expert unless, of course, there is a point or an issue that really does require the opinion of a non-lay person. In this case, we're nowhere near next stage. The allegation brought by the defendant in its counterclaim is set out in the counterclaim, and put simply, it is that Mr. Adil, the claimant, withdrew a total of $777,000 from the defendant's account, the company account, transferred it to his own account, and has failed to provide evidence of what he's used those monies for. There is unlikely to be any dispute between the parties that the transfer of those funds occurred. All that is disputed is the interpretation of what those funds have been used for. Now that isn't a matter for a forensic accounting expert, how the parties characterize or label any transactions. That is a matter for explanation from Mr. Adil, and it won't assist to appoint an accounting expert to determine whether the funds used by Mr. Adil were either used for the benefit of the business of the defendant or were used for his own benefit. All the accounting expert is ordinarily required to do is to identify where the money's come from, where it's gone to, whether it's been hidden, or whether it's been surreptitiously disposed of. In this case, there's no dispute about the sums, where they were, where they went to. The question is whether they were legitimately used by the defendant, either in the course of his position as CEO or managing director of the defendant, or for some other venture that was private to himself or for personal gain. We're not going to be assisted by an expert in his commentary about that, because that's a matter for evidence from Mr. Adil and from Mr. Suresh Chatterjee, the chairman of the defendant. And the court will ultimately have to decide which interpretation of the use of funds it prefers, the claimants or the defendants. And no expert is going to be able to assist the court with that.
Yeah.
And so in a case like this, Your Excellency, there is no requirement for an expert, and so the appointment of an expert is not reasonably required pursuant to RDC 3112. And I should also make the point, it's a procedural point, but it's an important point, and Your Excellency touched upon this at the outset when I mentioned that the claimant may be seeking the appointment of an expert. Under RDC 31.15, a party applying for permission, under 31.13, no party may call an expert or put in evidence by way of an expert's report without the court's permission.
Which is they seeking it today.
They're seeking that today, but under 31.15, when a party does apply for permission under 31.13, he must identify the field in which he wishes to rely on expert evidence. Now, in my submission, the claimants have unfortunately failed to do so. They haven't identified meaningfully and with precision the purpose of the appointment of the expert. I mean, what we're looking for is tell us what exactly it is you're going to instruct the expert to do, and they haven't been able to configure that or formulate that. And secondly, they haven't been able to identify an expert whose evidence they wish to rely on. When you look at their case management information sheet, which is set out at
12.
I think it's 13.
13?
Yeah. And it's the third page, paragraph 12. The question is, on what issues may expert evidence be required? And it's at this point that the claimants require to satisfy RDC 31.15 and formulate the kind of instructions or the issues that they be seeking the expert's opinion on. And to say simply, the issue of alleged misappropriation and false entry in the defendant's accounts doesn't take us any further. And so, if this is to be deemed an application under 31.15 with the court's permission, it is inadequate and insufficient and hasn't been improved upon by my learned friend today. And the next question is this a case in which the use of a court-appointed expert might be suitable? And then the claimant just sets out its belief that a court-appointed expert might be required to report to the court on the alleged misappropriation again, it doesn't take us any further. It doesn't tell us what it is that the claimant is seeking. So in my submission, the permission sought is defective and hasn't been approved upon by anything that my learned friend has said today. The appointment of an expert is not reasonably required. The court can determine whether those funds have been used for proper or improper purposes.
Okay. Yes, Mr. Moss.
Yes, if I will reply to that, I will, in brief, the defendant, it depends on that the dispute about the use, how that money has been used for the benefit of the defendant or for the benefit of the claimant himself. Actually, it is not the question. The question is, we admit that this money has been transferred to us, to our client, as an employment benefit. So, of course, he used that money for his favor. But the question that amount, the question is how that amount being transferred to our client's account, whether based on his only his sole signature, or based on joint signature from our client, the claimant, and the chairman of the defendant. This is the first one.
Okay.
The second one,
you can prove it by evidence, paper.
I'm coming. That the question for the expert is to identify the entry in the budget, because there was an increase in the budget that this amount has been transferred to the client as an incentive or equity grant for employment benefit. So that decision needs and requires the appointment of an expert to review the budgets and prove that it was recorded as an employment benefit until the budget and statement of account of the defendants of 2013. After thereafter, it has been changed from incentive and equity grant to another entity, which is advance or loan to my client, to the claimant. That is the issue, actually. If the court, however, if the court considers and Your Honor believe that it is not a matter of expert, we will agree to that. But this is our submission to that issue, and we insist on it.
Yeah. See, in my view, so far, based on the information and the correspondence before me, I see this case not an expert case. And in conclusion, there is no expert shall be appointed for this case, and still you have a liberty to apply for the court permission later. Pre-trial?
Yes, so we got until the 2nd of April under point 9, so it would make sense for perhaps having a progress monitoring date a week later, which would take us to Thursday the 9th of April.
Wait. Which point are you talking about?
I think
progress monitoring date?
Oh, sorry, yes.
Not a pre-trial.
Before passing this issue, Your Honor, if you pardon me, there is an issue that I want to
yes,
draw. Our client intends to apply for the issue of witness summons after the submission of a witness summary based on the rules of the JIC courts.
Say it again, sorry.
Our client intends to apply for a witness summons, to issue a witness summons after the submission of a witness summary from his end.
But see, in witness statement, how many witnesses you want to bring to the case, to the hearing?
Yes, my question.
We don't say you have to bring 3 or 4.
Okay.
Bring whatever you want.
My question was that is there any need to put a time limit for the issue of summons or something like that?
No need.
Or it's covered within the witness statement?
It's a witness statement.
Okay.
And you can make a chief witness. Yes, pre-trial, progress monitoring date. You said 2 weeks?
No, 1 week, Your Excellency. So the last date being the 2nd of April.
This for progress the case.
So perhaps the 9th of April.
Okay.
9th.
9 of April 2014. A pre-trial review. You think this case needs a pre-trial review, or will be ready for the trial?
think it's probably sensible to have a pre-trial review.
Okay, then usually the pre-trial review 4 weeks before the actual trial. Let's go back to let's fix the trial date first, then we'll go back to the pre-trial review. Which the convenient date for the trial for both parties?
Based on the defendant's proposed timetable, we have suggested that a trial not before the 19th of April, but of course that needs to be adjusted in light of the further time provided by the court in relation to the other deadline. So may I suggest then the week after that, which would be
5th of May.
Sorry, the 19th of April. The next would be the 7th of May. So not before the 7th of May.
Not before the 7th May.
Yes.
Nasser?
هو قال لي
We'll double check the. For how many days? 2 days or 3? You mentioned here 4 days.
We have 3 witnesses provisionally, Your Excellency.
Sorry, how many witnesses?
3 witnesses.
3 witnesses.
The first is Mr. Suresh Chaturvedi, who is the dismissing officer and the chairman. The second is Mr. Parashur, who is an advisor and deals with the management instruction issue. And the third is the assistant to Mr. To the claimant, Miss May Calabra. I don't think that their evidence is going to last more than a day and a half or 2 days at the most.
Okay, for 3 witnesses, let's say 1.5 day as an examine. Cross-examine will be 1 day. For opening submission and closing submission 1 day. I think 4 days is reasonable.
Perhaps even 5, depending on the number of witnesses.
Yes, because we, at least one witness summons will be issued through the court to one witness. It may be one of the witnesses that is suggested by the defendant himself. But at least I prefer to give us respite, like to add in 1 day for us for
Okay, see, then we'll fix it for 5 days, which is full week hearing, and in any progress or changing the time, we can discuss on pre-trial review. But I'm waiting the date. وجون معاشية. It's convenient 17th of May to 21st of May.
Yeah.
As a 5 days hearing.
17 to 20.
21st, 21.
Okay. Your Excellency, I've just asked a colleague of mine to check with the registry whether another hearing, which has a 5-day estimate, which I'm dealing with in another matter, has been listed or not, because I don't want it to overlap with this trial day. It's also a 5-day listing.
But okay.
There's no clash.
It's your colleague?
It is. Well, he's not my colleague. He was on a secondment with Al-Tamimi, which has come to an end as a Pegasus scholar. And as you know now,
And he'll help you here as an intern.
he's assisting the court actually, and for the next 3 months. Thank you. There's no overlap, so that should be fine. 17th to 21st.
Okay. 17 to 21st. Okay, then the pre-trial will be 4 weeks before, and 4 weeks will be
5th of
April.
May, 4 weeks. 4 weeks before the 5th of May.
Which date in April will be fine for you?
2, 3.
Pre-trial?
I think it's the 7th of April.
7? No, will be
15 it will be clear.
after the 15.
4 weeks before. 4 weeks before the
19?
15th of May.
15th May?
Oh, forgive me.
15th of April, you mean? 15th of April is Thursday.
Oh. Sorry, the trial date is listed for the 15th of May.
The trial date 17th of May
Forgive
to
me.
21st. And the PTR is
Friday.
now we're on PTR, 4 weeks before the trial.
It would have to be the
15th of April.
I think 18 or 19.
So April would be the
Will be 19, 18 Saturday.
19th.
Will be Sunday?
The Sunday, yes.
It's okay? And the pre-trial will be 19th of May 2000, April 2015.
and 2 weeks before
And of
the
course,
17th.
the cost will be in the case, and the party has a liberty to apply for any application they seeking permission from the court.
So, Your Excellency, the trial bundles would be the 3rd of May then, I assume.
See,
Leave it 2 weeks before.
this one I don't prefer to put it in the, but we apply the RDC, of course. You are both expert,
Okay.
and I believe you're following the RDC. And if you want to put it as a deadline, I'm happy to do.
3rd of May. I think it's always useful to have a deadline so that
Okay,
things
then-
don't.
Will be 3rd of May 2015. Trial bundle shall be served. Okay.
And Your Excellency, in terms of the reading this skeleton argument, opening statements and chronology, are you content for those to remain as they are in the draft?
Yeah, I think keep it as a draft, and we can discuss it in pre-trial review when we put a timetable for the actual hearing.
So,
Anything to discuss before?
nothing further. Yeah.
I think I'm fine. Thank you.
Thank you for coming, and Assalamu alaikum.